Well, first of all, let me make it clear that it is constitutionally right. We have the constitutional obligation to accept every order or judgment of court and to abide by such order. But it's also constitutionally right for you not to agree. One thing is to accept, the other thing is not to agree with the said order or judgment. That is why there are levels of there are levels you take such a decision to. You can approach the Court of Appeal, then you now go to the appeals court, which is the Supreme Court. And such decision, the decision of the Supreme Court on such matter, you will not only accept, but you also agree with such decision, because that is the final level you can go in litigation. So, to your question now, well, it really did not change anything. But you know what? Some of us who are observant and at the same time who go through the rudiments of the law through by this system set up by Nigeria legal educational system, you agree with me that the law is dynamic, so it changes and events result to such changes. What the court actually decided is it has right here matters of fundamental rights. Do you understand? But the other issue is whether the issue before the court, fundamental right, is the substantive issue. But that is left for the counsel for both parties to argue out before the court. But when it comes to issue of fundamental right, yes, the court has jurisdiction. If you look at section 46, subsection 1 of the Constitution, you will know that the Federal High Court and also the State High Court has jurisdiction to hear issues of fundamental rights. But what people are asking is, looking at the surface of the motion, looking at the surface of the process before the court, is fundamental right substantive? Is it the main claim before the court? That is what we'll look at when the court hears the substantive matter. But for his ruling, it did not change anything. And the substantive matter will still proceed, and the law is still valid. The law passed by the State House of Assembly, repealing the 2019 and 2020 Kano Emirate Council law, still valid.
All right, so I will still dwell more on the issue of if he has jurisdiction to preside over the matter. Of course, this matter, he had earlier given a verdict on it. And whether or not it is substantive, people will still want to question the rationale if this matter should even be at the table of the Federal High Court in the first place, because it's a chieftaincy affairs matters, and that should be dealt with by the courts in the state.
No, so yeah, you see, the people are missing things up here. Do you understand? Yeah. What constitutes jurisdiction on court is one, the party, to the subject matter, and these are contained in the process before the court.
Yeah.
So if the process before the court, which have been privileged to peruse, but I have my own personal reservation so that I won't predetermine the outcome. Do you understand? If the matter or the subject matter has to do with the fundamental right, and let me tell you one thing clear: issue of fundamental right can be instituted by any person on behalf of another person who alleges or who claim that such rights are likely to be infringed. So if Dan Agundi has taken it upon himself to say, okay, well, the right of Aminu Bayero is to be infringed or is already infringed, the law allows that. So let's look at it from the context of the fundamental rights. Then we'll now see, when my lord go into the substantive issue, because the truth is that issue of jurisdiction can be raised at any given time of the process.
Okay.
Even if my lord decide not to apply the argument of the respondent in the Federal High Court, it can be raised at the Court of Appeal. And there are cases where the court has held. There is one that is, we don't have same facts, but we have similar circumstances whereby you can rely on precedent on the authority. There's an Okorafor and others, which the Supreme Court is very instructive, and it has a scenario, should I say a similar issue in the context of leadership tussle.
Okay.
Do you understand?
Yeah.
And let's in that case.
Let's just wind back a bit. Look at it from where the problem actually started. The ruling or the verdict, whatever bill that was passed, that actually led to the deposition of Sanusi Lamido Sanusi II at inception as the Emir of Kano, was that actually valid to even start with?
The bill is valid.
On what grounds?
It's valid on the ground that, well, this is a bill, because first of all, you should look at the arms of government. We have the judiciary, we have the executive, and we have the legislative, which is the highest of it all. And if such a thing is passed, it needs the endorsement of the executive.
On what
and if
grounds?
you look at it,
on what grounds?
Well, this is a bill that was sponsored in the State House of Assembly. And you know, I've argued severally in this in several fora that irrespective of the procedure upon which a bill is passed, and it is acceded to by the executive arm of government, it remains law until it is interpreted by the courts to be null and void to the extent it contravenes the provision of the Constitution. But if you go back to now, my Lord in his wisdom, that is not what is before him. What is before him is if the rights of the party that is before him is infringed. And the court has jurisdiction to hear that. But that law that repealed or that scrapped the other existing four emirate council still valid and still exist.
Okay, now I understand that the Kano State government is here to respond. Do you think that, of course, it would be appropriate for them to repeal or react to this latest ruling?
Well, the only thing they can do is either one, they accept and agree with it, or two, they challenge it at the Court of Appeal.
Okay.
Or maybe the third option lawyers can look at, or maybe their counsel will look at, is to say, okay, well, let's hear the matter in totality. Okay. So that we will all follow it, because when you appeal, let's just hear the matter in totality. Let my Lord hear the substantive matter. Then whatever the outcome of the decision of my Lord in his wisdom, well, it's subject to an appeal by the Court of Appeal. Then also we have the Supreme Court, which the Supreme Court in their wisdom, we look at what my Lord has done and what the other court has done and make a pronouncement on it.
Okay, so finally, Tohwo, before I let you go, there's been some allegations or some aspersions cast on the person of Abdullahi Liman based on past judgments and verdicts that he has given. And some people feel that he has given verdicts that have been in favor of some certain personalities that he is in cahoots with. Do you think that he has that integrity in whatever guise to deliver?
Well, as a minister in the Temple of Justice, every court you see, we see them as a masquerade. Okay. And in their own wisdom, in their fine wisdom, whatever judgment he might have given is based on the wisdom and the processes before him. I've been privileged to appear before my Lord, and I've also been privileged to hear some of his decisions. And I will still tell you, from as a minister, they are just mere allegations. And you know, if such allegation and anybody has substantive proof, we have the process in which such an allegation can be proved and disciplinary actions can be taken. But if that process are not followed, it's just a mere allegation. You know what mere allegation mean? It can be referred to as something that is assuming until it is proven, accepted in evidence, and necessary actions will be taken. So we have, for me, I have confidence in my Lord that he knows what he's doing, and I have no reason to doubt his wisdom. But however, the courts, that is why you have redress. The Court of Appeal can decide to uphold this decision or set aside the decision. And oftentimes, we've seen similar things happen, set aside such decision, and the same time refer such officers for disciplinary action.
Okay, Tohwo Oseruvwoja, legal practitioner, thank you so much for your insights.
You are welcome.